हेलो एवरीवन, वेलकम बैक टू योर चैनल लॉपीडिया। आज के हम अपनी इस वीडियो में समझेंगे सम ऑफ द की एस्पेक्ट्स ऑफ योर इंफॉर्मेशन इन टेक्नोलॉजी एक्ट 2000. And why are we covering this act? We are covering this particular act in context of the recent ban that has been imposed on the Chinese applications. पहले आ जाते हैं आपके न्यूज़ पे. I hope you must be aware that the Indian government has banned 59 Chinese applications. And ये उन्होंने किया है under section 69A of the Information Technology Act 2000. Along with उन्होंने यूज किए हैं इंफॉर्मेशन टेक्नोलॉजी प्रोसीजर एंड सेफगार्ड्स फॉर ब्लॉकिंग ऑफ एक्सेस ऑफ इंफॉर्मेशन बाय पब्लिक रूल्स. एंड ये बैन क्यों इम्पोज किया गया है? बिकॉज द एप्लीकेशंस वर पोजिंग अ थ्रेट टू द सॉवरेनिटी एंड इंटीग्रिटी ऑफ इंडिया, डिफेंस ऑफ इंडिया, सिक्योरिटी ऑफ स्टेट एंड पब्लिक ऑर्डर. Along with the India-China standoff that has been continuously going on in Ladakh's Galwan Valley, ये particular applications overall India के security को भी threat कर रहे थे. How? Because there were many complaints received and there were many reports that stated that the data of Indian consumers have been leaked outside or is being used by the Chinese government for its own good. ना ही कि ये थ्रेट थे सॉवरेनिटी एंड इंटीग्रिटी ऑफ इंडिया के, दे वर थ्रेट टू द डेटा सिक्योरिटी एंड प्राइवेसी एज वेल. दिस पर्टिकुलर स्टेप ओवरऑल अगर हम देखें, इट इज बीन टेकन टू इंश्योर डिजिटल फ्रीडम ऑफ इंडिया. एंड दिस इज द टाइम प्रॉब्ली वी कैन इनोवेट एंड एक्सपेरिमेंट विद ऑल द जीनियस माइंड्स अवेलेबल इन आवर कंट्री. आई होप आपको ये कंटेक्स्ट क्लियर है. व्हाई आर वी टेकिंग अप इंफॉर्मेशन एंड टेक्नोलॉजी एक्ट इन दिस पर्टिकुलर वीडियो? सो लेट्स गेट started with the act itself. So now our Information Technology Act 2000. ये particular act formulate किया गया था to give legal recognition for transaction carried out by the means of electronic data interchange and other means of electronic communication. And इनको हम commonly क्या refer करते हैं as electronic commerce. बेसिकली यह एक्ट हमारा होलिस्टिकली कवर करता है ऑल दोज इलेक्ट्रॉनिक ट्रांजैक्शंस व्हिच एक्ट एज अ अल्टरनेटिव टू द पेपर बेस्ड मेथड्स ऑफ कम्युनिकेशन. So now we'll cover some of the important sections of your Information and Technology Act, जिससे आपको ये particular act और भी ज़्यादा क्लियर हो जाएगा. अगर आप सेक्शन 2 पढ़ेंगे इंफॉर्मेशन एंड टेक्नोलॉजी एक्ट का, वो ब्रॉडली ले करता है दी वेरियस डेफिनेशंस जो आपके थ्रू आउट द एक्ट यूज हुए हैं या यू मस्ट नो अबाउट. मैंने कुछ इंपॉर्टेंट डेफिनेशंस यहाँ पे स्टेट करे हैं विच यू मस्ट नो. एंड द फर्स्ट वन विल बी टॉकिंग अबाउट अ साइबर कैफे. ये एक्ट बेसिकली डिफाइन करता है व्हाट इज साइबर कैफे. साइबर कैफे बेसिकली मीन्स अ फैसिलिटी फ्रॉम वेयर एक्सेस टू द इंटरनेट इज ऑफर्ड बाय एनी पर्सन इन द ऑर्डिनरी कोर्स ऑफ बिजनेस टू द मेंबर्स ऑफ पब्लिक. सिंपल डेफिनेशन है, इन द कोर्स ऑफ बिजनेस अगर कोई एक्सेस ऑफर करता है कंप्यूटर्स का टू द जनरल पब्लिक or to the public at large, it will be called cyber cafe. Now it also defines cyber security. It defines cyber security as protecting information, equipment, devices, computer resources, communication and information stored from unauthorized access, use, disclosure, disruption, modification or destruction. साइबर सिक्योरिटी की एक कॉम्प्रिहेंसिव डेफिनेशन दी गई है आपकी आईटी एक्ट में, विच बेसिकली स्टेट्स दैट आप अपनी इंफॉर्मेशन को कोई भी अनऑथराइज्ड एक्सेस, कोई भी अनऑथराइज्ड यूज, डिस्क्लोजर और डिस्ट्रप्शन से प्रोटेक्ट करेंगे. नाउ अनदर इंपॉर्टेंट डेफिनेशन विल बी योर डेटा, which is defined under section 2O. Data refers to representation of information, knowledge, facts, concepts or instructions. And ये किसी भी फॉर्म में हो सकते हैं, including computer printouts और optical storage media devices, etc. ये define करता है data. Further, it defines what are digital signature. Digital signature basically होता है authentication of an electronic record by a subscriber by the means of electronic method or procedure in accordance with the provisions. So कोई भी रिकॉर्ड को अगर आप by the means of electronic method आप उसे authenticate करते हैं, वो होते हैं आपके digital signature. So the act contains elaborate provision with respect to the digital signature as well. So I hope आपको basically clear है कि section 2 में act के बात की गई है various definitions की, which you can read, and some of the important definitions I've just stated over here. Let's move forward to other key provisions of the act. So आपका section 43 basically बात करता है penalty and compensation for damage to the computer. ये बात करता है कि if any person without the permission of the owner, अगर हम owner की permission के बगैर और कोई ऐसा person who is in charge of the computer उसकी permission के बगैर access करते हैं या secure access करते हैं सच कंप्यूटर को, या कोई फाइल्स डाउनलोड करते हैं, या कोई कंप्यूटर कंटामिनेंट या वायरस डालते हैं उस कंप्यूटर में, या कोई भी तरीके का डैमेज वी डू विद रिस्पेक्ट टू द कंप्यूटर, और वी डिस्टरप्ट और कॉज डिस्ट्रप्शन इन द कंप्यूटर, या हम किसी थर्ड पार्टी को एक्सेस प्रोवाइड करते हैं इस पर्टिकुलर कंप्यूटर का, या आप डिस्ट्रॉय, डिलीट या ऑल्टर करते हैं एनी इंफॉर्मेशन, या आप कोई इंफॉर्मेशन को स्टील करते हैं, कंसील करते हैं या ऑल्टर करते हैं उस कंप्यूटर पे, you shall be liable to pay damages by way of compensation to the person so affected. So the next important section हम आते हैं section 43A of the act. ये basically बात करता है compensation for the failure to protect data. Now we are talking about data protection. So what all authorities we are taking over here, or what all stakeholders we are considering, or what all persons we are considering? Section 43 basically सिर्फ body corporate के बारे में बात करता है कि where a body corporate possessing or dealing or handling in sensitive personal data और इंफॉर्मेशन कंप्यूटर रिसोर्स जो वो ओन करता है या ऑपरेट करता है, अगर वो इस चीज को लेकर नेग्लिजेंट होता है in implementing or maintaining a reasonable security practices and cause करता है wrongful loss or wrongful gain to any person, such body corporate shall be liable to pay damages by way of compensation to the person so affected. So अगर हम data protection की बात करें अपने act के अंदर, so basically अगर आप पढ़ेंगे so you will realize it talks about only body corporates जो ये handle कर रही है data. अगर वो falter करती है and by that data is leaked, the sensitive personal information is out in the public, then it will be liable to pay compensation. So next important section जो आप देख सकते हैं, it will be section 66E. Section 66E basically talks about punishment for violation of privacy. Section 66E basically बात करता है कोई भी अगर intentionally या knowingly capture करता है, publish करता है और transmit करता है image of the private area of any person बिना उसके consent के, under the circumstances of violating the privacy of that person, such person shall be punished with imprisonment जो कि extend हो सकती है 3 years और with fine जो कि extend हो सकता है आपका 2 lakh rupees तक. So that's how important privacy of a person is under the Information Technology Act. Next important section आप पढ़ना चाहेंगे will be section 66F which deals with cyber terrorism. And there is a comprehensive provision जो deal करता है कि whoever with the intent of to threat the sovereignty, unity, integrity of the country or to strike terror in the people, अगर कोई भी ऐसा act करता है of cyber terrorism, the person shall be liable for imprisonment which may extend to life. Let's move forward to the other important sections. So now the next important section that we must all remember will be your section 67B over here. Section 67B basically prescribe करता है a punishment for transmitting of material depicting children in sexually explicit act in electronic form. It's a very very important section which protects the rights of children. So इसमें act ने state किया है कि such person shall be punished on the first conviction with the imprisonment of either description for a term which may extend to 5 years and subsequent conviction पे with the term which may extend to 7 years. So let's now move forward to your section 69, power to issue directions for interception or monitoring of decryption of any information through a computer resource. सो बेसिकली सेक्शन 69 गवर्नमेंट को पावर देता है कि वो कोई भी इंफॉर्मेशन को डीक्रिप्ट कर सकती है या डीकोड कर सकती है, या इट कैन इंटरसेप्ट और मॉनिटर सच इंफॉर्मेशन received in any computer resource जब ये particular act होगा in the interest of sovereignty and integrity of India, defense of India, security of state, friendly relations with the foreign state. So basically ये बात करता है कि कोई भी ऐसी information जो किसी computer source में है, government can very well intercept, monitor और decrypt such information अगर हम कुछ concerns address कर रहे हैं अपने nation के. Okay, so now the next important section will be a section 69 जो हम अभी इसकी next slide में detail में cover करेंगे. Before that, let's see section 69B. Section 69B basically ये power देता है to monitor, collect traffic data or information through any computer resource for cyber security. So basically section 69B ये provide करता है कि in the interest of cyber security अगर government ये चाहती है to identify, analyze, prevent any intrusion or spread of any computer contaminant या virus, government monitor कर सकती है, collect कर सकती है information generated, transmitted, received, stored in any computer resource. So government can very well do that when we are talking about cyber security. Now last जो हम इस particular slide में cover करेंगे will be your section 66D. तो ये section basically deal करता है कि कोई भी by the means of any communication device or computer cheat करता है by personation. What do I mean by personation? अगर कोई भी दूसरे की आइडेंटिटी अज्यूम करने की कोशिश करता है with the intent of cheating, it will be punishable under section 66D of the act, and such person shall be punished with an imprisonment of term which may extend to 3 years and shall be also liable to fine which may be extend to 1 lakh rupees. So that's the important sections of your act. I hope आपको ये clear है. Now let's move forward and understand our section 69A. So now section 69A of the Information and Technology Act 2000. अब मैंने इसको different components में break किया है. Let us understand. Section 69A basically talks about अगर कोई भी government या उसका भी कोई भी officer satisfied है that in the interest of sovereignty and integrity of India, defense of India, security of the state, friendly relations with the foreign state, public order, or for preventing incitement to the commission of any cognizable offense. And अगर वो इन criterias को लेके satisfied है, it may direct the government or intermediary to block the access by public of information generated, transmitted, received, stored or hosted in any computer resource. So I hope आपको ये basic chronology clear है कि अगर ये factors satisfy होते हैं which are stated over here and any of these factors government is satisfied with, the government can direct the intermediary to block the access by the public of the information that is generated, transmitted, received, stored or hosted by such a computer resource. And अगर कोई भी intermediary fail करता है to comply with the directions issued by the government, such a person shall be punished with the imprisonment जो कि extend कर सकती है 7 years तक and will also be liable to pay fine. So some criteria have been specified which if fulfilled the government can block the access by the public of such information in any computer resource. Section ने punishment भी prescribe करी है. So now let us move towards section 66A of the act जो कि struck down किया था सुप्रीम कोर्ट ने श्रेया सिंघल वर्सेस यूनियन ऑफ इंडिया के केस में. So सुप्रीम कोर्ट ने ये कहा कि this particular section is arbitrary and vague. ये जो हमारी right to freedom of speech and expression है, it is very well restricted in certain special circumstances जो कि आप अपना आर्टिकल 19 of the Constitution पढ़ेंगे आपको समझ आएगा कि वहाँ पे कुछ reasonable restrictions prescribed हैं जहाँ पे आप एक individual की freedom of speech and expression पे curtail कर सकते हैं. However, अगर आप अपना section 66A पढ़ते of the Information and Technology Act, आप ये रियलाइज करते कि जो ग्राउंड्स प्रोवाइडेड थे अंडर सेक्शन 66A फॉर द रिस्ट्रिक्शन ऑफ फ्रीडम ऑफ स्पीच एंड एक्सप्रेशन वो हमारे कॉन्स्टिट्यूशनल नॉर्म्स को कंप्लाई नहीं करते थे एंड दस वो कोई भी रीजनेबल रिस्ट्रिक्शन नहीं थी ऑन आवर फ्रीडम ऑफ एक्सप्रेशन. सो कोर्ट ने अपहेल्ड किया इस केस में फ्रीडम ऑफ स्पीच एंड एक्सप्रेशन विच इज वन ऑफ द मोस्ट वैल्यूएबल राइट्स गिवन टू एनी सिटीजन इन द डेमोक्रेटिक इंस्टीट्यूशन. So let's read section 66A so that you can get an idea that why it was struck down. So basically section 66A ये बात करता था कि कोई भी person who sends by the means of computer resource any information जो कि grossly offensive है, which is harmful in character, or the information that has been used by the person he knows to be false but for the purpose of causing annoyance, inconvenience or obstruction. वो ये particular information send करता है by the means of computer resource or communication device. Such person shall be punishable under section 66A of the Act. Another key component of the section would be any person who sends any electronic mail or any electronic mail message again for the purpose of causing annoyance, inconvenience or to mislead another person. So अगर कोई भी person ऐसा कोई इलेक्ट्रॉनिक मेल या मैसेज सेंड करता है जिसका एम है टू annoy or to cause inconvenience or to mislead the person itself about the origin of such message, such person shall also be punishable under section 66A. And इस सेक्शन ने पनिशमेंट भी प्रिस्क्राइब की थी that such a person shall be liable for imprisonment for a term which may extend to 3 years. Now let's move on to the last but the very important topic of our IT Act when you're talking about is your data protection. So, IT Act was not enacted with the primary purpose of providing data protection. आपके IT Act में explicit provisions नहीं हैं इतने सारे जो कि personal data of a person protect करें. And the scope and applicability of IT Act does is very very narrow. However, अगर आप देखें data is now emerging to be one of the game changers in the business industries and often हमारे big business houses are all about collecting, organizing, processing information and data. And most of the times these data includes the personal information of an individual. So let's see, आपका Uber owns no vehicles by itself. It's just operating on this data platform जहाँ पे आपका सारा data synchronize होता है एक particular application पे and then you book a car. Facebook itself creates no content. It's all we who are creating the content on the platform. And Airbnb also for an example, आपकी accommodation है but actually itself it owns no real estate. So अगर आप ऑब्जर्व करें business these days are data driven and data is becoming the new king in the business industry. It's all about processing the data and generating it for the better use of consumers. And इस सब के बीच में our personal sensitive data is also involved. So at the same time while we are growing our business opportunities, we need to be careful about our personal data, what we are doing on that front. So हम समझ लेते हैं इसके some of these certain key provisions so that you can understand what key components are we working when we're talking about data protection in India. So basically जब आप इस bill के key provisions पढ़ेंगे you will realize so bill relates to the personal data of individuals and उसकी processing, collection and storage. And under the bill, data principal is the individual whose personal data is being processed and एक entity और individual जो ये decide करती है the means and the purpose of data processing आपकी described as data fiduciary under the bill. So जो आपका scope and ambit of the bill है ये बहुत wide है, government भी included है and companies incorporated in India are also included. And it also governs foreign companies if they deal with the personal data of individuals in India. Now the first key aspect will be the protection of personal data of individuals. Bill ये provide करता है the data principle that is us whose personal data is being processed. They have been given certain rights with respect to their personal data. And these rights will include their right to seeking confirmation when their personal data is being processed, seeking correction, completion or erasing of their data, seeking transfer of the data to other fiduciary and restricting continuing disclosure of their personal data. सो ये पर्टिकुलर राइट्स दी गई हैं टू डेटा प्रिंसिपल इन द इंटरेस्ट ऑफ प्रोटेक्शन ऑफ द पर्सनल डेटा ऑफ इंडिविजुअल्स। एंड बिल रिस्ट्रिक्शन भी प्रोवाइड करता है कि जो हमारा पर्सनल डेटा है इट कैन बी प्रोसेस्ड ओनली फॉर स्पेसिफिक क्लियर एंड लॉफुल पर्पसेस। एंड द बिल ऑल्सो प्रोवाइड्स फॉर सेटिंग अप ऑफ डेटा प्रोटेक्शन अथॉरिटी। एंड ये अथॉरिटी कंप्राइज करेगी मेंबर्स विद द एक्सपर्टीज इन द फील्ड सच एज डेटा प्रोटेक्शन एंड इंफॉर्मेशन एंड टेक्नोलॉजी। Basically, it will act as a grievance redressal mechanism for the protection of the processing of personal data of individuals. And the bill also prescribes certain grounds for processing of personal data जो कि हम already discuss कर चुके हैं. It should be for clear and lawful purpose. And next question जो आप पूछ सकते हैं कि are there any exemptions to these safeguards for processing personal data? कोई एग्जेम्पशंस हैं जो अंडर बिल प्रोवाइड की गई हैं कि कौन सी सिचुएशन में आप एग्जेम्प्ट होंगे? यस, देयर आर सर्टेन एग्जेम्पशन व्हिच हैव बीन गिवन। अगर कोई भी डेटा चाहिए इन द इंटरेस्ट ऑफ सिक्योरिटी ऑफ द स्टेट, पब्लिक ऑर्डर, सॉवरेनिटी, इंटीग्रिटी ऑफ इंडिया, फ्रेंडली रिलेशंस विद द फॉरेन स्टेट, and processing of personal data is also exempt from the provisions of the bill for certain other purposes such as prevention, investigation or prosecution of any offense or research and journalistic purpose. And कोई भी person का data process कर सकती है state without their consent in cases of medical emergency, in cases of legal proceedings and in cases if state wants to provide certain benefits to the individual. Now, ये act also contain करता है provisions of certain offenses which deal with processing or transferring of personal data that is in violation of the bill. And the bill also contains provisions with respect to sharing of non-personal data with the government. So जब we are talking about data, we can classify into personal and non-personal. Personal data जो होता है it pertains to the characteristics, traits or the attributes of individual identity. मतलब हमारी identity क्या है which can be used to identify a particular person whether it's person A or person B. Non-personal data की बात जब हम करेंगे it may include information such as location of the person. So I hope आपको personal data protection bill absolutely clear है. Now let's understand the last dimension which I'll be covering in this particular video, which is very important. So the last dimension you can see is what model should India adopt when we are talking about data protection. So अगर आप US का मॉडल देखेंगे it allows collection of personal information as long as the individual is informed of such collection and use. However, this particular restriction has been often viewed as inadequate in key respective regulation. And अगर आप यूरोपियन यूनियन के केस में देखेंगे it has been criticized for being excessively stringent, imposing many obligations on the organization for processing of personal data. So आप यहाँ पे two dimensions देख रहे हैं. On the one hand, there are certain less restrictions. On the other hand of European Union, there are more restrictions. India must factor out a middle path, that is an approach which is between both of them. So that's it for today's video. I hope आपको IT Act और the Information Technology Act comprehensively clear है. हमने उसके बहुत सारे aspects पे बात किया, हमने उसके sections cover किए. Then we cover the last and the very important dimension which is our data protection law and our Personal Data Protection Bill 2019. So thank you so much for watching. Please do click the subscribe button so that you're notified whenever I'm uploading a video. And till then, stay home, stay safe and keep learning.